The small estate affidavit in Maine. What is a small estate affidavit? A small estate affidavit is a sworn statement of a person who considers themselves eligible for getting inheritance by the descendant, who left assets of value less than a state statutory limit. The document is considered an option for those whose close ones died not owning enough property to qualify for probate according to their state laws. The affidavit might also be used by the creditor of the descendant proving the debt on oath before the court. A small estate affidavit might concern any property left by the descendant: bank accounts, jewelry, art, vehicles, money, and real estate in some cases. Typically, a small estate affidavit is used when there is no last will. However, some states allow the use of an affidavit in conjunction with the last will, depending on certain legal requirements. In all states, such a document requires attestation by a notary public or other official authorized to administer oaths. Why do I need a small estate affidavit? If your spouse or parent has died, such a document will help avoid long probate court proceedings and associated costs and take possession of the property left by your close person immediately. Having the affidavit form accepted by the local probate court, a claimant can require a bank or other entities or people who currently possess the estate previously owned by the descendant to give it away to them. However, in certain situations, it would be wise to first seek legal advice before filing the small estate affidavit form. For example, when the beneficiary has not reached the age of majority or is disabled. When chances of a will contest are quite high. When the descendant has left unpaid debts, or when it is impossible to create a comprehensive list of the descendant's property and assets. A few words about a small estate affidavit process in Maine. In the state of Maine, a small estate affidavit is referred to as a collection of personal property affidavit. Maximum value of such property cannot exceed $40,000, minus liens and encumbrances. An affidavit can be sent no earlier than 30 days after the descendant's death. Assets transferred in such a way might include motor vehicles and real estate. To make the affidavit accepted by the probate court in the Maine county where the descendant's estate is being handled, make sure to have prepared the death certificate, the title of all property owned by the descendant, the original will, if any, properly filled collection of personal property affidavit, a sample of which you can find on the Maine Probate Court website. If the court accepts the document, you will receive a court-certified copy of the small estate affidavit. It will let you get the rights to the property mentioned in the affidavit.